Hi there, how are you? Hi, can you see me? There, hi, I'm Lori. Can you see me now?
Yes, I can, Lori. Can you see me?
Excellent. Yes, yeah. How are you today?
I'm very well, thanks. How's it going?
Doing well. Nice to meet you.
Nice to meet you.
I presume you're Susan.
I am, sorry, yes.
No, that's all right. I know there are a couple names on the email, Susan. So, yeah, thanks for being a part of this today. I appreciate you doing the webinar. What we'll do is we'll do a little testing, and then I will have you just maybe mute your sound and your audio until we're ready to go live at 1 o'clock.
Okay.
So I'll show you around just a little bit. Two questions for you. First one is, would you like attendees to be able to ask questions as we go along, or would you prefer that it be all at the end? Do you have a preference?
Hang on 1 second. I moved something and I just lost you. Let me see.
Okay.
There you are. Okay.
Yeah, how would you like questions? How do you prefer to take them as a speaker?
I do prefer to take them as we go, and if it looks like it's going to get completely off track, I'll simply say, why don't we hold questions to the end? Because sometimes it results in greater engagement, and sometimes it derails whatever point I'm trying to make.
In between, yep. No, I totally understand that. So, okay, so we'll do them at the end. And, you know, sometimes we don't have many. It really depends.
Okay, and they come to you? Is that what happens?
Yeah, well, there's a chat moderator that I'll just keep an eye on, see if there's questions, etc.
Okay.
So I will keep an eye on those. So the name of today's webinar, Sarah had coined it as IP brand protection. Is that correct?
Yes.
Okay. And I have your bio. I will read through that. All right, this is how I'm going to share the screen. So at the very bottom, you'll see a menu. If you put your cursor on the bottom strip of the view that you have, you'll see the share screen. So I will share my slides with you, or you would share yours. So you would go to that spot and do share.
I'm going to do share.
And then you'll be able to share whatever slides you're showing.
So you know what I'm going to do right now is I'm going to
open your slides.
I've opened them. I'm going to actually close everything else because I don't want, hang on 1 second. Let me just,
probably wise.
Right. Let me just delete a few things here.
Yep.
All right, wait 1 moment. Okay, I'm going to close this. What I'm wondering is why, oh, I see. So I'm just wondering why certain things, I'm going to get rid of this. I'm going to get rid of that. Dismiss all. Let me dismiss my snipping tool. Hang on 1 moment. Snipping tool. Let's get rid of you. I do not want to save changes. Just wondering why. Okay. I'm going to close this. I think I can close this without losing you. We will see. If I lose you,
you can just log back in. It's not a problem.
Log back in. It says Outlook. Okay. So now what I'm going to do is I'm going to share my slides. Here we go. Share. So you're going to tell me when you have these slides.
I can see those. Yep.
Okay.
So you'll just
if I do this.
Your start from the beginning.
Right.
Oh, thank you for putting our logo on there. Looks great. Yep.
Yeah.
And so, yeah, depending on how you have the format or the boxes at the top of your screen, you can see yourself, see what the video looks like. See me. I'll mute my video. So once I say hello and I do an introduction to you, I'll just turn it over to you, and I'll mute my video and sound, and I'll hang out if there's any issues, any concerns, if I can't hear you or something.
Great.
Usually I'll mute myself, and you might want to mute yourself until we get started. I'll give people, a couple-minute warning. We're going to start in a couple minutes. Oftentimes when people come back, they, as a speaker, they forget to unmute themselves. So make sure when you come back, you unmute yourself. But basically, you just take it from here. You do your normal pace. We leave, the last few minutes for question and answers. if there are question and answers, we'll go through them then with your attendees, and then encourage folks to reach out to you if they have further questions. Oftentimes people will ask for the slides, and if you'd like, we can send them the slides or send you the list of folks to send it out. If it's something you want to share, that's up to you.
That's perfectly fine. And you know what happened? I was trying to make sure that I could find the unmute, and then I lost the share. Let's find this again. Let me just eliminate this. And if
I can still see it, so it hasn't gone away until you undo the share. So there's up at the very top of your,
yeah.
At the very top you can see there's view options, there's another green. It says right now, it tells me that I'm viewing Susan Cornfield's screen. It's
So
probably something you did in review.
I cannot see the slides. I can see the slides on my computer screen, one of my computer screens. Maybe I'm just moving this. Hang on one second.
I don't know. Play around with a box that has different formats for. There's a box. Typically, mine's right now up on the right-hand corner that I can change if I want it to be in 2 panels or if I want it to be in 1 panel.
Okay.
I picked on one of those.
I think we're good. Where is the icon that you want me? Oh, there is the mute. Okay, I've got it. I think I'm all good now.
Okay. It's a pretty good tool. We use it for our webinars. It works pretty well. So we used to use WebEx, but we've had better success with this, less technology problems. Sometimes there's a hiccup, but majority of the times it works quite well. So
right.
All right. So
okay.
If you're good, I will take my photo and my picture down for a few minutes, and then I'll come back up a few minutes before, tell people we'll be starting in 2 minutes, and then I'll come back and say who I am, what the webinar is, and then introduce you and hand it over to you.
Very good. I'll put you on mute then.
Great. Okay. Thanks, Susan. We appreciate you doing this.
You bet.
This is Lori Berman from the Small Business Association of Michigan. We'll be starting in just 2 minutes. 2 minutes, we'll be starting. Thank you for joining us. All right, well, welcome everyone. Thank you for joining us this afternoon. My name is Lori Berman. I'm the Vice President of Membership and Development for the Small Business Association of Michigan. I welcome you to today's webinar, Intellectual Property Brand Protection for Your Entrepreneurs, or for entrepreneurs, I'm sorry. I just wanted to say this is a part of a series of webinars that we do for our members with partners such as Bodman. Today we have Susan with us, and I'll give her a proper introduction in a second. I encourage you to watch the SBAM website for other webinars that we schedule on a monthly basis. There'll be more coming up. And also next week is the SBAM annual meeting that will be held on Thursday, June 20th at the Lansing Center. If you'd like more information, you can go to www.sbam.org, sbam.org. So let's get right to it, folks. One thing, if you need to pop out, this webinar will be recorded. It'll be placed on our website, downloaded sometime next week. You'd need to be logged in as a member to view it at a later date, but it will be available on the SBAM website under the Resources tab. So let's get started. Today we have Susan M. Cornfield. Susan is chair of the Intellectual Property Practice Group at Bodman PLC, and an adjunct professor at the University of Michigan Law School. She has been selected as an expert witness, mediator, and arbitrator in intellectual property disputes, and has been recognized as a leading trademark attorney in Michigan by Managing IP. She serves on an advisory committee to Stanford University on matters involving libraries and academic information resources. She served on the 2008 advisory committee to the University of Michigan College of Engineering that resulted in the creation of the Center for Entrepreneurship and the advisory committee to the Provost on Copyright Matters. Susan is the recipient of 2 of the State Bar of Michigan's most prestigious awards, the 2014 John W. Comiskey Pro Bono Award for significant pro bono contributions, and also the 2017 Intellectual Property Section Excellence in IP Award for leadership and achievement in the field of IP law. Susan has been recognized by the best lawyers in America and has received the highest peer ranking from the Martindale-Hubbell for professional excellence and ethics. She was a board member for the Humane Society of Huron Valley and has been in court as a volunteer attorney representing cruelty investigators animal rescuers, and veterinarians. So thank you, Susan. Excellent background. We're really looking forward to what you have to share today. And I'm going to turn it over to you and let you take it away.
Thank you, Lori. And good afternoon to all of the SBAM members. I'm assuming you can hear me. And if you can't, please send an email to Lori. I'm going to race through a bunch of slides that I have with me. You are free to get a copy of these slides. And I'm going to also ask you to ask questions as we go. So first, I want you to see what we intellectual property attorneys sometimes consider to be all of the various intellectual property doctrines. We're not going to cover all of these in today's discussion, but I want you to see how trademark, which is really the heart of branding, but how it's just one of many other intellectual property doctrines. So trademark is going to cover the company names and logos, product packaging and design, and that's where we're going to spend about 70% of our time today. We're going to spend some time also on copyright, which covers creative content. We're going to touch on trade secret, and we're going to spend just a minute or so on patent, again, just so you're aware of how that plays out in your business. And then intellectual property can also include rights of privacy, rights of publicity, data, and in certain countries, and this is important if you have international trade and international exports, it can cover industrial design. We're going to talk about a very interesting industrial design case that was just decided a few days ago. So moving on, we see here a picture of the Winklevoss twins, as a friend of mine calls them, the Winklevi. And I use them to represent some of the challenges that a small business can encounter when it is being formed and it is collaborating with individuals and there isn't any documentation in place about that collaboration. So if you've seen the film, The Social Network, you'll know that Mark Zuckerberg was one of a handful of people who were collaborating at school. Now I'm going to go to the next slide here. They were collaborating on what ultimately became Facebook, and a dispute arose about whether or not there were oral contracts, so nothing in writing, just words exchanged among the collaborators, whether there was in fact an oral contract that gave the Winklevoss twins entitlement to some of the stock of Facebook, whether they were going to be retained to build the Facebook site, whether they had contributed some of the ideas that made their way into the Facebook product, and actually whether or not source code or documentation that they had created was used. This case settled in 2008, as it says there, for $65 million. The important takeaway, I think, for small business is that when you do not document your collaborations, you can actually result in people who are not necessarily trying to steal anything from you. They walked away with a different understanding of what the deal was and what their role was and what they were entitled to either as a member or an officer or an investor of the company. So when we talk about intellectual property, even though it is in some sense, it is a niche area of trademarks, copyrights, trade secrets, etc., it also is intertwined with business doctrines, such as whether or not there's a contract, whether somebody participates as a member, whether there's a duty owed by somebody else. The next slide, I think, is a great example of how, again, collaborations that are not documented can result in disputes. And what we have here is a case that made its way all the way to the US Supreme Court. The case involved the Community for Creative Nonviolence, which is a homeless advocacy group, which contracted with Mr. Reed, who was an artist, to create a particular sculptural work. And you see the sculptural work here. It's an image of a couple huddled over a grate. There's a shopping cart in the background. As you see, there's the phrase, "and still there is no room at the inn." And what the issue was that ultimately had to be decided was who owned this creative content. Was it CCNV because it hired Mr. Reed as a contractor, but hired and paid Mr. Reed to create this work, and indeed was very involved in talking about what what the figure should look like, that a shopping cart should be included, that they would be huddled over a street grate, or whether Mr. Reed owned it because he's an independent contractor. He was not an employee. So the message, the takeaway for you here is that when you or your employees are collaborating outside your organization, or when you are bringing in a contractor, you might not own the rights in the work product. You might own the thing that was delivered to you that you contracted to have created, but not own the rights to make additional copies, the rights to give copies to others, the right to adapt it into new formats. And what happened with the case involving the Community for Creative Nonviolence is the Supreme Court said, a couple of basic rules here. Companies do own the copyrights, the intellectual property rights in the work product created by its employees when it's a part of that employee's job responsibilities. But that doesn't necessarily apply when you bring in contractors. So that's when it's very important to work with your attorneys. This even happened with Spike Lee when he created a film, Malcolm X, about 15 years ago, 18 years ago, and he brought in a consultant just to work on 1 or 2 scenes. And that consultant later claimed that he was brought in to be a co-owner of copyright. And although Spike Lee ultimately won the case, again, the takeaway is you don't want to be paying lawyers to litigate. You want to pay lawyers a much more modest fee at the outset to be sure you have the right contracts in place. So it's an interesting reminder that even very famous people working in very big industries, probably lawyers everywhere, didn't think to have a contract in place with this consultant who was brought in for 1 scene. We also see here an interesting story that arose a few years ago in Detroit. And if you've been to Detroit recently, and in fact, a lot of cities are benefiting by beautiful murals being painted on the sides of buildings. I happen to love this particular mural. It's called the Bleeding Rainbow. And it was created several years ago. And then a company purchased this building a couple years ago and announced it was going to punch certain holes in the walls of the building to create lofts. And the artist, Katie Craig, said, "No, you're not. I own the copyright in that mural." And that mural has generated such attention and commentary and recognition that it actually has become a work of stature. So what you're going to see in this next slide here, and I'm not going to read these next 2 slides to you, they're very long, they're very dense, but the point is that works of the visual arts can have a separate set of rights. You might never think about it when you're engaging someone to create a sculpture for you, or a mural, or in some cases, photographs. But as you can see here, 2 of the rights that that an author of a work of the visual arts can have is the right, what we call of attribution, to claim that they are the owner. And look at that in that first bullet point, halfway through, the right to prevent a distortion, mutilation, or other modification of the work that would be prejudicial to their honor or reputation. And that is why in the second bullet point, you will see that that works of the visual arts, authors have what's called rights of integrity. This is about a 20-year-old amendment to the U.S. Copyright Act. It is not litigated frequently, but it is something that you need to be aware of if you own a building or if you're going to have an artist create artwork. And you'll see here in the next slide, just about 4 months ago it was posted, that a settlement was reached. Here's an artist rendering on what this building is going to look like. There will be some holes punched in the wall, but not through the artwork. And they believe the artwork is actually going to lend itself to some of the aspects of the building that will make it a unique place to work. The next slide, next couple of slides talk about what happens when your employee leaves and goes to work for a competitor or actually creates new products for a company that competes with you. It raises the age-old question, who owns what? So we see Barbie. Barbie was, at this time, the #1 selling doll in the world. I believe that still may be true. And there was an individual, Carter Page, who worked at Mattel, but he did not make dolls. He made accessories for dolls. And he left Mattel, and he went to work for MGA and created the line of dolls called Bratz. By the way, this is a $500 million a year industry, the Bratz line of dolls. So whatever industries you are all in, we should get out and we should go into doll making. And the question was whether or not Mattel could stop Carter Bryant from going to another company and making dolls. And this did not involve a case with a non-compete. It involved the question, did Carter Bryant have an obligation to go to his employer and disclose a new idea? He didn't even have the dolls at that point. He had the idea for a new line of dolls. So as you see in this next slide, it raises the question. I sometimes label it, can a company own an employee's mind? But perhaps a more precise way to state it is, when do you want to have, either by a contract or by policies, when do you want to have an employee have an actual obligation to come to you for a product you are not currently making or for an improvement to your product and have a duty to disclose it to you? The Mattel MGA litigation went on for 8 years. In fact, I think there was an article that said 8 years later, and the only thing that's happened is the lawyers have made a lot of money. And that's because this case went back and forth between the trial court and the Court of Appeals. It is a reminder to you that sometimes the law is unclear and you can bring more certainty to your business operations and the ownership of inventions through contracts and through policies. And even when you have a full-time employee, this was a case many, many years ago where an individual created the quick release socket wrench, and the individual worked at Sears but did not work as an inventor. This person did not invent tools. And the question was, who owned this invention? Initially, Sears claimed it owned the invention. In fact, Sears and its lawyers engaged in some very unethical conduct and actually lied to Mr. Roberts. They did get in trouble for that, I'm happy to say. And the litigation went on for a very long time because, as you probably know, this is a very popular product. I think I myself own a collection of 8 of them. But here the question is, even when someone's an employee, if they're not actually paid to invent, who's going to own these new inventions? And again, you can deal with this by contract. So now we're going to move into the area of our discussion that's primarily branding. We're going to talk a bit about copyright and trade secret at the end. So first, what I want you to think about is when we use the word trademarks, a lot of us typically think of the first 3 bullet points. We think about words and designed letters, stylized letters, or logos. But as you're going to see, your business assets can actually include a lot of other things that function as trademarks, such as sound marks. You might think about computer programs that when you open them, there's a certain orchestral sound or a tweeting sound. But each of these other elements, sound, motion, color, smell, we call these olfactory marks, touch marks, and trade dress are a part of your business assets. So for words, I want you to think of your business name or your product names. So as we say here, a word mark is literally a word. Hershey's, Kleenex, Kellogg's. It's slogans, and it's your company nickname. In fact, Federal Express for a long time fought people calling it FedEx. It kept saying, our name is Federal Express, our name is Federal Express. And one day it realized everybody called them FedEx, so they should go ahead and secure protection for the name FedEx. Then we have stylized letters. And what this means is this is an element of your brand that I, as a customer or a prospective customer, I recognize in part because of shape and color. So when we talk about stylized letters, we mean protection not just for the word Kellogg's, but for the way this word is depicted with the particular script in a particular slant, shape of the letters, etc. So Kellogg's, Google, these are all, this is protection for the visual color and shape of the word, not just the word itself. So here we have logos. You can protect a logo separate and apart from a word. The NBC Peacock is an example of a mark. There are probably 15 different registrations for that mark, and that's because the company updates its logo from time to time, and it secures registration each time it does so. For those of you in the techno world, you may recognize the trademark, the logo for Ghostly International, a record label that was actually begun by Sam Valenti when he was a student at the University of Michigan 20 years ago. Now here's something that even a low-tech company can think about in terms of brand protection, and that is product labeling. So here we have one of the most famous trade dress in terms of product packaging, one of the most famous in the world, certainly in the US. Very simple color combination, stylized letters, Campbell's, certain design elements like that sort of shield that appears in the middle, very plain, which for some people makes it a much more distinctive and less cluttered appearance. That is protected as a trademark, that packaging. So if you're going to be selling things that come in packages, you might want to think about, how can I make my packaging distinctive through color and through graphic elements so that somebody could spot it halfway down the aisle. Here's an example with the For Dummies books. Even though when these books first came out, I have to admit, I was one of those people that did not think For Dummies was a great name for a product. But maybe after, I don't know, $1 billion worth of book sales, maybe I was wrong about that. But what you can see is that even something as low tech as a book can have a distinctive cover, and indeed the For Dummies trademark for the cover of the book is protected. So here we have a few examples coming up of how you can use color to protect your product. In this case, it's the color pink for insulation. So Owens Corning is because of its federal registration, is the only company in the US that can make insulation in this pink color. And you have to use a product for a long time to create that association in the mind of your customers, but it can be done. Another very well-known example is the Robin's Egg Blue for the Tiffany's jewelry box. So Tiffany's is the only jewelry company that can sell jewelry in that color box. AstraZeneca decided that AstraZeneca was a complicated name and it was going to come up with a pill called Nexium. And they also called it the purple pill. And as you can see here, they secured domain name registration for purple pill. They also secured domain name registration for the purple pill. They made the pill purple. And they have the design elements of the 3 stripes. So they have protection not only for patent on their pharmaceutical, as you can see, they have trademark protection for the phrase, the purple pill. Another example of a very well-known product design, and again, this is for you to think about at the outset of your product development phase. Think about how you can add elements that are unique and distinctive, and that will result actually in your company being the only company that can make a product with that particular shape or color combination. So this is a very early version of the Apple iPod. Here's an example of an inexpensive, low-tech product that is also protected by trade dress. Trade dress refers to the actual shape and color of the product itself, not the packaging for the product, the product. And you can see on the left, there's a little dust pan and a little dust broom, and it's clearly related to the product on the right, which is a squeegee. So here's a product that costs about $9 or $10, but they put some real thought into color and shape and making it distinctive. And OXO is the only company that can sell those products with those colors and that shape. I'm going to go through the next couple of slides quickly. But what's interesting here is there was a fight between Christian Louboutin and Yves Saint Laurent over the red sole on this red shoe. And the question was, here is a United States trademark registration for a red sole, which is owned by Christian Louboutin. But if you look very carefully at the text there, it says the mark consists of a red lacquered outsole on footwear that contrasts with the color of the adjoining upper portion of the shoe. And for that reason, oops, let me just back up here. You can see why Yves Saint Laurent was allowed to use a red sole with a red upper because of basically market demand. The market sometimes requires that a shoe have a particular look. And what this means is when you are deciding product color and product shape, be sure you consult with your trademark lawyer, because in some cases, your use of color will be considered functional and not aesthetic. We only protect the aesthetic elements of product packaging and product shape. Here's a case that came down just a couple of days ago, June 12th, 2019. It involved a company that wanted to make a French press coffee maker, and they decided to imitate the elements of the Bodum product because they thought that the Bodum product was not particularly distinctive and that all of the elements they copied were functional. But as the court said, there are many different ways to design the shape of a French press coffee maker and many different ways to design the feet. And this kind of copying was infringing the trade dress and awarded $2 million. $2 million. So don't just copy someone else's product without consulting your lawyer. And more importantly, notice how important the creative elements were in the design of this coffee maker in the first place. It actually resulted in a court concluding that the Bodum coffee press shape was distinctive. And moving on, we see the layout of the Apple Store. There was enough consideration given to the layout of the store that the Trademark Office, the U.S. Patent and Trademark Office, issued a trademark registration for the retail design element of the store. Here's the design that was submitted to the Trademark Office. And here is a very detailed description of what is protected. The purpose here, and if you read all of this text, I'm not going to read it all to you, but you'll see they look at lighting, they look at where the glass is placed, they look at the horizontal panels, the shelving, and it means that when you are a business and you are designing your floor layout and the look of your retail establishment, give some consideration to creating something that is unique in your industry, that doesn't just look like every other store of your type, and you can get trademark protection in certain cases. So now I'm going to give you a little pop quiz. See if you can tell what is the problem with this product that was launched by two sisters. They decided to create a shoe that women could roll up and stick in their purse or their briefcase so that at the end of the day, when they took off those shoes that hurt their feet, they could put on something very soft and comfortable. And they called these footsie rolls. So the footsie roll shoes. So you probably can tell the problem. It is both the word mark and the stylized letters, because you've probably heard of this product, Tootsie Roll. And the company that owns this trademark brought a lawsuit against these two entrepreneurs and said, we have a famous trademark called Tootsie Roll, and you are trying to make our trademark less distinct. You're trying to get some kind of bump associated with our goodwill. And here they are showing their shoes. They complained about how much money they spent on legal fees. I think what I would say is if they had paid about 15 minutes for an attorney up front, they wouldn't have been sued in the first place, because they would have come up with something like this, Footsie Folds. And that was the name they had to change to. So it's a reminder again, you choose a mark that is too similar to someone else's trademark, you can get sued and you can have to start all over again with your rebranding. 2 years ago, we had the highest award for trademark damages in the history of the state of Michigan. You might recognize 5 Hour Energy on the left and on the right. Don't ask me why a company thought they could come up with 6 Hour Power, but they did, and they sold it for several years, and they were sued and they lost. Why? Because the question is not whether your trademark is identical to someone else's trademark. It's whether your trademark is similar enough, and the products are similar enough, and the trade channels are similar enough that the consumer will think there is some relationship between the two. And as the attorney for 5 Hour Energy said, the purchaser could have thought that 6 Hour Power was just a new product in this line of products, or was a stronger version. I think it was a $14 million verdict. So here's what you're going to want to think about. You want to have as distinctive a mark as you can. And when I say distinctive, I mean a word or a slogan that, if you look at this next bullet point that says trademark power hierarchy, you want to choose either a word that you made up, like the word Kleenex or the word Google, or the word Visteon, or a fanciful mark, meaning where you take 2 words and combine them, like Microsoft, or an arbitrary mark, like Apple for computers or music. So the word Apple exists, but Apple Computer is the one that linked that word with its product. Or what we call a suggestive mark. A suggestive mark means you hear the word, and it sort of conjures up certain qualities or certain aspects of that product, but it doesn't actually describe the product. And Downy is a good example of a suggestive trademark, Downy for fabric softener. At the bottom of the heap, and the reason I put it in parentheses, is what we call a descriptive mark. And a descriptive mark simply describes the product. And you cannot get trademark protection for a word that just describes your product unless over many years and with the expenditure of many funds, you can show that in your industry, that phrase is now just associated with you. I have 2 slides that I'm going to race through. I just want you to be aware that when you ask a lawyer, is this mark that I want to use a problem? Is it going to infringe someone else's mark? We lawyers look at about a dozen factors. And so here are the list of some of the things we look at. And we look at these factors because the Trademark Office in Washington, D.C. will look at some of these factors or most of these factors. And courts will look at these factors if there's going to be litigation. So first you'll see how similar are the words themselves. And when we say similar, we mean how similar does it sound? How do we pronounce it? What does it look like? What's the impression that's made by the mark? We look to see how similar the goods or services are. We look to see how similar the trade channels are. How sophisticated are the consumers? Because the more expensive your product is and the more sophisticated your purchaser, the more care that they use. And so they're usually able to make distinctions between marks that otherwise might be similar. We look to see how widely used a word is. We look here to see what is the likelihood that a company that is in clothing is going to bridge the gap between clothing and, let's say, cosmetics. Or they're in software, what's the likelihood they're going to bridge the gap between software and, let's say, technical services? Pretty similar. So there's a number of factors that we look at, and that's why we sometimes give you answers such as, I think there's an 85% chance we can get this one through the Trademark Office. So let's see whether you think, in a couple of instances coming up, these marks are likely to cause confusion. So there was one company that had registered the mark on the left with the star and the bear and the surfboard, and it says Republic of California. And then there was an applicant, and let me back up, the registered mark was for clothing, and then there was somebody who applied to register the phrase California Republic. What do you think happened there? Did the trademark office say those two marks, given that they are the same good, those two marks are too similar? The answer is the trademark office said they're different enough because the graphic design element is so prominent and so distinctive that it really makes a different impression than the words California Republic. Here we have a registered mark, Lafayette, for vegetable salads, and then somebody applied to register the Lafayette for sandwiches. So a little different mark, different goods, but as you can probably tell where this is going, the trademark office found that they are related enough that they would cause confusion in the marketplace. So the company that wanted to register the Lafayette for sandwiches was refused registration. So this is sort of interesting here. Pepsi applied to register Polar Shock for these slushy drinks, kind of the sort of drink you get at a 7-Eleven. And Polar Company had been around for about 100 years, selling primarily water, also at places like 7-Eleven. And Polar actually brought a lawsuit against Pepsi, claiming that Polar Shock was too similar to Polar, that even though there's an entirely additional new word, shock, the fact is that Polar is the first word in each of those marks. And indeed, the court agreed with Polar, ordered Pepsi to stop using the mark, and actually ordered Pepsi to send its staff back to the stores and take the product out of the stores. I mean, that's a very serious order. So what it means is we can't think that just by adding one word, we can avoid a trademark problem. Also, a lot of our clients want to know if they can register their last name or if they can use their last name in a business. And it all depends whose last name and whether it's already a trademark. So here we have Rihanna, who was asserting that her father could not use his last name, Fenty, because not only is it her last name, it's her trademark. So here we have several different trademark registrations for Rihanna, for Fenty, by Rihanna. So makeup, cosmetics, etc. Fenty Beauty, Fenty Glow, Fenty with the N backwards. So if you have a last name that you want to register, even though there can be certain challenges to registering last names, we'll have that discussion separately. What you should know is just because it's your last name does not mean that you get to use that word if someone else already has it registered. So if your last name is McDonald's, you're not going to be shocked when I tell you that you're not going to be operating a hamburger drive-through store. Take just a couple of minutes and talk about what it costs to get trademark registration and what's usually involved. So what you should know is clients choose their mark and we run searches. Clients choose a mark, we let the client know how strong or distinctive we think that mark is, whether we think it's likely to be refused registration by the trademark office because it's too weak. We run searches, online searches and searches of the trademark office database. If we think there is a pretty decent chance you can get it registered, we will file the application. The trademark office, Patent and Trademark Office, PTO, will review the application. There is an opportunity for the trademark office to refuse registration on grounds that the mark is too weak or that it is descriptive, that it's likely to cause confusion with other registered marks or pending applications. There's a whole list of reasons. There is an opportunity for other people to oppose if they think that your mark is likely to cause confusion with their pre-existing mark. Usually if things go well, it's about 9 months from filing to issuance of a certificate of registration. And it's usually about $2,000 all in terms of trademark searches, getting the application on file, responding to trademark office questions unless there are significant refusals. And you should also know that if you file an application in the US, you have 6 months to file in many, many countries internationally and get the benefit of that early filing deadline. Let's talk about why clients might want to go ahead and secure federal registration. So first of all, it means once you have a federal registration, and by the way, this can all be done online, so nobody has to go to Washington, D.C. to get these on file. It means that certificate of registration is prima facie evidence, basically proof you own that mark. Most importantly, you have exclusive rights nationwide to use that mark with those goods or services. There's only a couple of exceptions, one being if somebody else had used the mark first in some other local jurisdiction, they did not have a federal registration. Your registration will not extinguish their rights, but you will freeze them in place. You are in a better position to stop other people from using the same or similar marks, so think Polar Shock or think Lafayette. If there's going to be a trademark battle, trust me, you would much rather be the party that has a federal trademark registration than nothing. It is easier to protect your domain name when you have a federal registration. It is a requirement if you want to be able to ban the importation into the US of goods from outside the US that have an infringing mark. If you want a license or co-brand, having a federal registration puts you in a much stronger position. It also makes your company a little more valuable, and in some cases a lot more valuable if one of your biggest assets is brand, in the event of the company being acquired. I had a client a few years ago who had a trademark registration for many, many, many years, and they were contacted, it was a very small company, they were contacted by a very large company who said, "We've been wanting to extend into that brand for a long time. We keep waiting for you to forget to renew your registration and you never do. We'd like to buy your mark." And they bought it for several $1 million, which was a lot of money to my small client. It's easier to get international registration. Again, we can file applications internationally from our offices. We don't have to always retain local counsel. And registration is one of the few IP rights that can, trademark is one of the few IP rights that can last forever. So you can renew it every 10 years, so long as you continue to use the mark. And the last bullet point notes, it helps to give you certain remedies in the event you find an infringement. Now, with all of these reasons for registering a mark, the next slide will tell you how lawyers like myself, who have encouraged clients to secure registration, nothing we said was ever really as effective as when this little company called Amazon created the Amazon Brand Registry and basically said to companies, "We will help protect your mark in our marketplace if you have a US registration." And then suddenly, what a surprise, how many companies thought it was really a good idea to get trademark registration. So here you'll see in the online questions at Amazon, brands must have a registered trademark to be eligible to join the brand registry. The trademark must be a standard character mark. That's what we call word mark, standard character mark, meaning not just the logo, not stylized letters, but the word itself. And you'll see here the US is one of the countries which, if a mark is issued, is registered in that country, it will be respected by Amazon and actually policed by Amazon. And we have had, on behalf of clients, we have had many products removed from the Amazon platform because of our clients' US registration. Very, very valuable. Oops, I want you to remember also that although a state registration is not nearly as valuable, it does have some value. First of all, it's fast. If we get an application on file, you will usually get your certificates back in a few weeks. It's cheap. It's a $50 filing fee. The level of review at the State of Michigan office is not as in-depth as it is in the Federal Trademark Office. There is no opportunity for people to oppose. They can later challenge, but they cannot oppose once you file. And as I said here, it is better than no registration at all. And indeed, if you were to have a dispute with another party, it would be better to have a state registration, which can give you statewide rights in that mark. And then I just don't want you to forget, because sometimes people will say, I don't have a trademark. And what they're really saying is, I don't have a registered mark. And they have what we trademark lawyers call an unregistered or a common law mark. But those still have rights under trademark law, and in some cases, very powerful rights. I had a situation a few years ago where a very small company, one retail establishment, called and said that they read in the paper, this was back in the days there was a paper, they read in the paper that a competitor was opening a store about 7 miles away. It was a national chain, and the name of the company was virtually identical. And the client wasn't sure they could do anything because they didn't have a federal registration. So I sent a letter to the company. I went online and I saw that they had a pending application to register their mark. I sent them a letter and I said, they cannot open that store 7 miles from our client because our client was there first and their registration hadn't issued, and they had applied to register years after our client had already commenced use. And the lawyer tried their best to explain to me why they thought they could still open that store. And I said, I'll tell you what's going to happen. We're going to oppose your registration. We're going to drag this process out probably 1 to 2 years, and we're going to win because the marks are virtually identical and the services are identical. And there was a long silence, and they said, can we buy your client's mark? And they ended up actually coming up with a number my client wanted to accept and change the brand of his store, the name of his store, over about a 2-year period. So that unregistered common law mark, because they were there first, was enough to prevent a competitor from opening a store nearby. Just a couple of points. Even when we have registered marks, it doesn't mean that there aren't other uses of our marks. So here's an example when Aqua came out with the song Barbie Girl. I'm a Barbie girl in a Barbie world. Life in plastic, it's fantastic. I won't give you all of the lyrics. And Mattel sued, claiming you can't use our trademark Barbie in your song Barbie Girl. And the court said, yes, they're making fun of Barbie. So you can use somebody else's trademark for parody purposes. Again, we have to go through a series of facts to analyze it, but here's an example of using someone's trademark to criticize them. So McMurder, over 1 billion animals killed. This is a great example in the US. This is considered speech. If this was done in the UK, it would be considered libel. So you have to know your country when you're going to engage in protest and criticism using someone else's mark. But here's an example, though, of many ways in which you can use someone else's mark, and it is not going to be an infringement. So an example would be news reporting. Even though the owners of the Boston Marathon tried to prevent a company from reporting on the Boston Marathon and using the words Boston Marathon, and the court said, of course they can use the words Boston Marathon to refer to the Boston Marathon. They're not running their own, setting up their own race, calling it the Boston Marathon. They're reporting on your Boston Marathon. So scholarship, teaching purposes, including even this presentation today. Comparative advertising. So if you are going to use the trademark of a competitor in your ad in order to talk about your product and why your product is better, and maybe that it's cheaper or that it has higher reviews, there are ways that you can use your competitor's trademark that are perfectly lawful. You will want to be sure that you have claims about your product that are true and not misleading and not deceptive. And if you're making any claims about product performance, you do have to have data to substantiate your claims. But you can use trademarks of others in order to comment, criticize, engage in parody, teaching, news reporting, etc. Here's an example of not a trademark, but we call it right of publicity, the famous face of Tiger Woods. And he brought a lawsuit years ago against a company saying, you cannot sell images of my face as your artwork. And the court said, yes, they can, because this particular artist had a series of artwork called The Masters of Atlanta. And it was basically speech, First Amendment protected speech in the form of art. So just a reminder that when we hear about intellectual property rights, and they are very powerful, but they are not true monopolies. We're going to take a couple minutes now, I'm just keeping an eye on the time, to talk about copyright. So we talked about trademark for the last half hour or so. Now we're going to talk about not just the name of the product, but the creative content. And copyright protects literary materials, music, plays, photographs, drawings, architectural drawings, motion pictures, music. But as you'll see in this third bullet point, there's a lot that copyright doesn't protect. Facts, data, the results of research, ideas. And the reason I bring this up is we are used to hearing about the power of copyright owners. But you need to know that sometimes you can use published content. The real question is, what are you using? If you're using facts, that's fine, because the copyright owner does not own the facts. You can use the results of research. So let me give you a couple of examples. First of all, here's the slide I was just referring to, talking about the kinds of material that copyright covers: literature, music, dramatic works, etc. This slide is one that I spend a lot of time on when I am working with my scientist clients and my engineers and my technical people. It's really, really an important sentence. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. In no case. What does that mean? That means that you are free to use books and articles and film, etc., so long as the part that you're using is the part that is not protected by copyright. So here's an example. There was a film made, The Longest Night. It involved a horrible circumstance of someone being kidnapped and placed in an underground coffin and breathing through a straw all night, but she was rescued. And Miller, a news reporter, wrote up the facts of that event, and then Universal City Studio did consult that article in putting together the film. And although Miller sued, saying, "You copied from my article," the court said, essentially, the question isn't whether or not they used the article. The question is, what did they use from the article? And they used the facts, and they used the research. And so that is perfectly lawful because that was not owned by the reporter. Another example, there was a battle over recipes. We often hear a lot of name calling on the web when somebody copies somebody else's recipe. But a court ruled there is no protection for recipes because they are just a combination of facts and processes. I know this is a lot of cases to throw at you. It's really for the purpose of trying to unlock the grip that copyright sometimes has on us when we think that when someone owns the copyright in a book, they own every word in that book, and they don't. So here we have the famous Michael Jackson, and a well-known photo was taken about 25 years ago, a long time ago. And we see here that his shoe company, Nike's company, has the Jumpman logo. And a couple of years ago, the photographer who owned the copyright in the photo on the left claimed that Nike couldn't use the logo on the right because the photographer said, it looks like the photo. So here's a comparison of them just as logos. But the court said, this is not, you don't own Michael Jackson, you don't own Michael Jordan. That the logo is a silhouette of a man doing a particular leap, like a ballet-inspired grand jeté. And let me just back up here, whoops. That is not what is owned by the photographer. The photographer owns the copyright in that photo, not in the outline of Michael Jordan with a basketball in his hands in a certain form of a leap. A couple of points about the evolution of copyright and technology. So here we have Cooper. He lives in Seattle, and his owners put a little camera on him one day, and he went out, and Cooper took these photos. And you'll see he's lying in the weeds. There appears to be the a dandelion gone to seed, and one of Cooper's friends, they're hanging out under a car, apparently. I think that's a car, yes. And the point really is, who owns the copyright in these photos? Because there's a emerging issue going on in the world of technology, and that is, who owns the copyright in images when there is no human that is pressing the shutter of that camera? It's being taken randomly, in this case, with an algorithm that was embedded in the technology around Cooper's neck. So we're going to take a minute or so and talk about some of the risks of copying content from the web. First of all, while it is true that copyright doesn't cover everything, it is also true that a lot of clients think if something is on the web, it's free for the client to use, and that's, of course, not true at all. Sometimes clients will say, I got this content, I got this photo from a website that is allowing me to make copies. And what I would say to you is you need to read that language carefully, or truthfully, your lawyer needs to read it carefully, because sometimes you're allowed to use it, but you can't make a commercial use. Or you can use it, but you have to give attribution. So if you look at that third bullet point, there is a separate part of the US Copyright Act that says, even when someone has given you permission to use something for free, if they've conditioned it on your acknowledging them as the photographer, as the copyright owner, and if you don't do that, it is a $2,500 fee at a minimum. I also have a bullet point in smaller font there of a website at Cornell, which will give you a very handy chart to understand how long copyright lasts and when copyright in public domain materials, or when the copyright expires and you're free to use certain materials. Here's an example of an advertisement by Audi of, you can see Jennifer Lopez driving her car past a particular outdoor mural. And it was used in the ad. And if here's a picture of that mural, it's hard to tell, but in the lower right, there's a copyright notice. Sort of an indication that these artists right here knew very well that their artwork was protected by copyright. And indeed, Audi met with them and worked out a deal where Audi paid a fee for the use of their mural in the ad, and also engaged them to create a new mural. By the way, I just heard a few months ago, there was a company that was sued for using artwork from certain Detroit murals in their ads. And I thought to myself, how does it get this far that someone thinks they can run an ad for a product using artwork that appears in a public space without thinking, could there be a copyright on that artwork? So why do we seek copyright registration? We seek copyright registration because if you don't have a registration, you cannot enforce your copyright. So the good news is your copyright exists at the time you create your software or your photograph or your film or your text. The copyright exists automatically. But if you want to enforce your rights, if you want to be able to get attorney's fees, if you want to be able to get certain kinds of damages, you get a copyright registration. What you see here from one of the bullet points, it lasts between 95 and 120 years, depends whether or not it was published. And it is easier to get or to claim a greater value for your company assets when your creative work product is registered. I want to take 1 minute. I know Lori, I only have a couple minutes left. Just a couple of minutes to talk about trade secret. And that is because trade secret is one of the areas of intellectual property law that is not registered. So for you to claim a trade secret, you need to undertake measures that are reasonable under the circumstances to maintain something as confidential. So here's an example of some of the trade secrets that you can actually engage the FBI to investigate. Like I said, trade secrets are not registered. And it usually happens where you've been hacked or when a former employee or former contractor leaves and takes confidential information or data or technology with them. Here's some of the examples, a couple of slides here, that clients can implement in order to show a court or an opposing party that they've undertaken measures that are reasonable. So you use contracts, you have company policies, you put notices up, you have to educate your staff, and remember, staff turns over every now and then, so you're going to want to do ongoing education. Physical security. So for example, people shouldn't be able to get into every drawer in the company where your secrets are kept unless they have a need to access that drawer to do their job. But as you can see here, I have 3 slides giving you about a dozen different things you should think about doing. You don't have to do them all, but you should think about doing those in order to show that you have met the standard of undertaking steps that are reasonable under the circumstances. The last couple of bullet points here I think are very important. You don't have to disclose everything to a competitor or a strategic partner. Just disclose what needs to be disclosed. Do exit interviews and remind people, because sometimes people think that when they leave, their obligations to you are over. So you need to remind them, no, 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 those obligations remain. And be sure you get back the materials. So this is an area of law where trust is very important because there is no federal registration or state registration of copyrights. I do want you to see there was a case where a court ruled that when a company took no measures whatsoever to protect the confidentiality of the technical specifications of their product, they had actually no rights at all, no rights that under trade secret law in their specifications. So as we know here from Stormy Daniels, that even when you have a signed NDA, there are going to be circumstances where they are not enforced. And one example would be whether that NDA was used in the connection with a crime. Here's a comment from an attorney from England who said, basically, it's not often a commercial lawyer is called upon to comment on the President of the United States, an actress in the adult entertainment industry, and confidentiality agreements. But the point is, as many people are learning now, you can't use an NDA to silence whistleblowers. And that actually was a new part of the trade secret law in the US just about 2 years ago, and or to cover up crimes. So for my last slide, I wanted to remind you that sometimes it's not always the intellectual property rights that protects you, it's the deal that you reach. And here was a deal that was originally reached in the 1800s. It had to do with a new formula for a product later called Listerine. And after Warner Lambert had paid royalties for about 50 or 60 years, they said they were done paying royalties because there was no trade secret left in this formula and there was no patent. And the court said the contract that you entered into didn't put a limit on when a royalty was owed. You agreed, your predecessors agreed years ago, so long as they used a certain formula, they would pay a fee. So sometimes it's really the deal that you reach that ends up being the most valuable part of your assets. And then you'll see I've also included in my slides a link to certain sites that I find very useful. And I'm going to end with a photo. I think this is the only part of these slides with a photo that I actually took, and this was my 21-year-old cat. So Lori, I don't know whether you have any questions from the participants you wanted to bring. Yes.
Thank you. There are a few. Amazing information, really in depth. I appreciate you going through all the examples. I think it's great to see the actual case studies of things that have happened. The first one I have is, how many years after filing can you use it without problems before someone else can file it? That was at 238, so I'm thinking they were asking for what we're talking about.
I think.
Sorry?
The trademark?
Yeah.
So the trademark rights, there's 2 ways that you have trademark rights. One is you begin using the mark just in a common law sense, even before it's applied for, even before it's registered. So one way you can get rights is by using a mark. And again, this assumes that we've run those searches and there's nobody else out there that has superior rights. Nobody else can commence the use of a mark that is similar to yours once you get that application on file. So the day that the application is filed is considered notice nationwide, even if people don't actually know. The law says they do know, and they cannot commence the use of a mark so long as your application ultimately issues to a registration. So even if it's pending for a couple of years, nobody can commence use of a similar mark during that time period. It's very, very powerful.
Excellent. Second question, what if I have someone model something I'm selling and let that person keep the test product that they're modeling?
Mm-hmm. So there's two issues that may be raised by that really three. One is when you have a model, you are using someone's face, possibly their body. So you want to have a release where they are actually giving you a right of publicity, right of privacy release that allows you to use their face, their body, their expression to sell your products. And if they keep the product, it's fine for them to keep the product. That can be part of the consideration that you're paying them. If they are a blogger and they are writing about your product, they actually have an obligation to tell their audience that it was given to them. So this is a Federal Trade Commission issue, so that when you are reading things online, you're entitled to know when another company gave someone that product, whether it was for free or whether the person writing had to pay for it.
Great. And then the final one is, if my name is Yoda, then is it a bad business name? Yoda's Interesting Things. So I guess the question is, using their name, is that a bad business name?
Well, I would put it this way. It's well known that where there are famous words, Yoda may qualify as a famous word.
Okay.
That you might not be able to use it in connection with your business if people would think that there's an actual Star Wars or George Lucas or whoever owns the copyright in that at the moment. What we would typically do is run common law searches and online searches to see whether or not it's already being used by other people. So thinking about whether it's a bad name would require us thinking, are you likely to be sued by somebody who's going to say, you are falsely associated your product with our company?
Mm-hmm. Right. Excellent. I don't see any other questions at present. Again, very comprehensive. I really appreciate what you shared. I think it really popped out at me, the slide that you had, that relatively low cost to protect these things can save you from a lot of expense in the end, someone else taking your market. I found it interesting, the company that ended up selling their logo or trademark, whatever it was, to the competitor that was impinging on their territory, had been waiting for them to not renew. So that's interesting to know that there are others watching, and your IP can be very valuable. So that was good. Thank you so much. Go ahead.
I was going to say, I'll send you a copy of the slides so that any of the members who wish a copy can download those.
All right, and we'll send that out, and then next week we'll have this up online. So again, thank you. Great information. I really appreciate it. And thank you everyone for joining us.
Thank you, everyone. Bye-bye.
All right, bye-bye.